Hi, Miss Christina. My name is Cindy, and I really need your help. My husband Danny, he's been physically abusing me for a long time, and I think it's time for me to divorce him. Please help me. I need to know whether I can divorce him and what steps I must take.
The first issue is determining whether the court has jurisdiction under Section 48, subsection 1 of the LRA. The court that hears petitions for divorce in Malaysia is the High Court. In your case, Section 48, subsection 1, which is that the marriage is registered or deemed to be registered in Malaysia, as most likely fulfilled since both parties were living in Malaysia at the time of their marriage. Thus, the next issue is determining if Section 48, subsection 1c, which is that the domicile of the parties to the marriage was Malaysia at the time the petition was made, is fulfilled. Next, we have to determine your domicile. Under Section 47 of the LRA, application of English principles is allowed. As a result, the definition of domicile is taken from Lord Cranworth in the English case Wicker and C, where he stated, by domicile we mean home, the permanent home. There are three types of domicile: domicile of origin, domicile of choice, and domicile of dependence. Only one domicile can be active at a time. As stated by Goh Siew Lin in Domicile and Divorce, under Malaysian law, the domicile of a married woman follows the English common law position in Charnley and Betty, where it was held that the domicile of a married woman is that of her husband while the marriage subsists, even though the parties may be living apart. This has been affirmed in cases such as Ang Gek Chu and Wong Tu Yong. Due to this, your current domicile is a domicile of dependence and will follow Danny's domicile. Next, we have to determine Danny's domicile. Danny is Korean, thus it is extremely likely that his domicile of origin is Korea. However, it is possible that Danny has acquired a domicile of choice in Malaysia. According to White and Tennant, a domicile of choice is acquired by a combination of two things: actual presence or residence in a country and the requisite intention. Since Danny has been living in Malaysia for the past 6 years, factum is established. In order to fulfill the requisite intention, the individual must show that he intended to remain in the country permanently or indefinitely. In Irvin and Irvin, the court held that a man who had resided in Netherlands for 20 years for work purposes did not acquire domicile of choice there, even though he married a woman domiciled there. Similarly, Danny has been staying in Malaysia due to a work commitment. The fact that he married a Malaysian does not mean that he has acquired a domicile of choice in Malaysia. Since he has not done anything to show his intentions to remain in Malaysia permanently or indefinitely, it is unlikely he has abandoned his domicile of origin. Hence, it is very likely that the active domicile of both of you is Korea, and unfortunately, Malaysian courts will not have jurisdiction under Section 48, subsection 1. Despite this, you don't have to worry, as you will still be able to petition for divorce under Section 49 of the LRA. According to Section 49, subsection 1b, courts will still have jurisdiction if the wife has been resident in Malaysia 2 years prior to the commencement of the proceedings. Since you have been in Malaysia all your life, you fulfill this requirement and can petition for divorce under Section 49. In Malaysia, there are two ways of dissolving a marriage. However, it is extremely unlikely that the first method, annulment under Section 68 of the Act, will apply to you. As a result, we will only be looking at divorce. In general, a person will only be able to petition 2 years after the marriage as per Section 50, subsection 1 of the LRA. Since you have been married to Danny for 5 years, you will be able to present a divorce petition without issue. Although there are 4 methods to divorce under Malaysian law, only 2 methods are applicable to you. The first is divorce by mutual consent. Pursuant to Section 52 of the LRA, both parties must mutually agree to end their marriage by presenting a joint petition to the court. A divorce by mutual consent is one of the fastest ways to obtain a divorce. As per Sivanesan and Shimala, there is no need to prove that the marriage has irretrievably broken down or that reconciliation has not been successful. For the first hearing, both parties must be present to establish free consent. According to Rule 10.4 of the Divorce and Matrimonial Proceedings Rules, DMPR 1980, a petition shall be presented by filing it with an affidavit verifying the petition has been signed by both parties, and a copy of any statement report regarding arrangements for the children of the marriage. However, given that Danny has been abusive to you, it may not be safe for you to ask him for a divorce by mutual consent, as he may get angry and harm you when you tell him that you want a divorce. You don't have to worry though, because pursuant to Section 53, you could also attempt divorcing Danny via the second method, which is on the grounds that the marriage has irretrievably broken down. Under Section 53, subsection 1, either party may present a petition for divorce under this ground, and as a result, you do not need Danny's consent to divorce him under this method. As for Section 53, subsection 2, you must then prove that the marriage has indeed broken down. In proving this, you could attempt to rely on Section 54, subsection 1b, which is that the respondent behaved in such a way that the petitioner cannot be reasonably expected to live with the respondent. According to the test given by Justice K.C. Vora and Joseph Jagannathan and Rosaline Joseph, this requirement would be fulfilled if a right-thinking man in all the circumstances would think the behavior unreasonable. Although domestic physical abuse is not strictly covered under Section 54, subsection 1b, as stated by Dr. Dalalir Kaur Randawar, case law is clear that domestic violence, defined under Section 2 of the Domestic Violence Act, DVA 1994, is sufficient grounds to fulfill this requirement. In the case Savinder Kaur and Dharma Singh, the court held that even vulgar abuse and minor assault on the petitioner fulfilled this requirement. In your case, the assault cannot be regarded as minor, as throughout the course of the abuse, you have fractured your wrist, lost 3 teeth, and miscarried several times. Since this requirement has been more than fulfilled, and domestic violence is something no person could reasonably be expected to live with, it is extremely likely that you will succeed under this ground. According to Rule 10 of the DMPR, in order to file a petition for a non-mutual divorce, the petition must be accompanied with an affidavit verifying the petition, a copy of notice of proceedings, a form of acknowledgement of service, and as per Rule 7.2, a copy of any statement report regarding arrangements for the children of the marriage. Ordinarily, according to Section 106 of the LRA, parties must first attempt to go through a reconciliation process before a petition can be made in court. In your case, this would not be ideal since you have been a victim of domestic violence. Under Section 106, subsection 1VI, this can be skipped under exceptional circumstances. In the case Vivian Lee, Xia Li, and Xia Chong Liang, it was held that domestic violence fell under this exception as reconciliation was impracticable. As a result, it is likely you will be able to skip the reconciliation process. Under Section 61, generally a decree of divorce will first be made by way of a decree nasi for 3 months. During this period, the parties are not yet officially divorced. However, as seen in Chin Yok Yin and Tan Tiam Huat, in certain domestic violence cases, the decree nasi for the divorce would be made absolute immediately. In conclusion, it is extremely likely that you will be able to successfully petition to divorce Danny. Furthermore, you may be able to skip the reconciliation process and may receive a decree absolute immediately. You may also be interested to know that during the divorce proceedings, according to Section 5, subsection 1 of the DVA, during the divorce proceedings, you may also apply for a protection order to protect Danny from using domestic violence against you and exclude him from the home. Additionally, the court allows you to claim compensation for personal injuries as a result of the domestic violence under Section 10, subsection 1 of the DVA 1994.
Hi, Mr. Nakiran. My husband has left me and is planning on marrying his lover. I'm going to be moving to Australia, and I would like to know if I can claim sole custody and guardianship of all 5 of our children. I've emailed you any other relevant details. Please help me.
Hi, Mary. As nothing on contrary has been given, the court will have jurisdiction to hear your petition for the custody and guardianship referred to as CNG henceforth for the 5 children, presuming the marriage is registered under LRA and both parties are domiciled in Malaysia. The Supreme Court in Saraswati and Balakrishnan confirmed that an application for custody can be made as an independent action. However, the first issue is whether CNG can be handled together, as LRA speaks only about custody, whereas Guardianship of Infants Act 1961 GRA elucidates on guardianship. Wu Min On argues that by reading sections 3 and 5 of GIA together with section 89 subsection 1 of LRA, the guardian of the child also have its custody. Bhagirathi and Gunasiran explained that custody is equivalent of guardianship in the fullest sense and requires it to be examined together. Thus, guardianship and custody will be explained together as a single constituent in my advice. Moving on. As the federal court in Amarapati and Muniandi confirmed that the right to apply for CNG under section 88 of LRA is limited to the parents of the child of the marriage only, the second issue is whether are you entitled under section 88 subsection 1 of LRA to claim CNG of all 5 children. Despite being married to Frank only for 3 years, you are the biological mother of 4 children aged from 5 years to 10 months, as well as the stepmother of Frank's son, who has been accepted as one of your family for the last 5 years. It is clear that your first two children were legitimized under Section 4 of Legitimacy Act 1961 and Frank's son is brought into the family from a previous relationship. So, as your right to apply for CNG, Sections 87 and 88 of LRA provides that a parent can claim CNG of a child born for the parties of the marriage and also a child of the party to the marriage who was accepted as one of the family by the other. Thus, you can claim for the CNG of all 5 children under the same application as they do all fall under the definition of the child of the marriage as provided in Section 2 of LRA. Furthermore, Abdul Malik asserts that Section 11 of GRA and Section 88 subsection 2 of LRA provides that the welfare of the child will be the paramount consideration deciding CNG of the child. So the third issue is whether will an enroll of CNG of all 5 children to you will protect the welfare of the children. The federal court in Mahabir Prasad and Mahabir Prasad held that a child's welfare is an overriding consideration and emphasized that welfare must be measured not only by money and physical comfort but also moral and religious interests of the child. So it is important to consider whether the extramarital affair of Frank will provide substantial ground for you to claim CNG of the children. As a child's moral is vital for the welfare of the child, Ling Sui-ching and Chen Kui-siang affirmed that CNG should be given to the mother as the father has abandoned the matrimonial home due to his extramarital affair, and it would be morally wrong to expose the children to the lover as the children will thoroughly be confused on the moral difference between marriage and extramarital relationship. Similarly, in Siu An Lau and Yi Kin Ming, the father's lack of morality was considered harmful to the welfare of the child, and thus it is highly likely that you will get the CNG of the children to protect their welfare as Frank has left the house for his lover. Also, the court in Pu Cheng Ni and Lubin Chu Pao Sing held that the other factors under the common law and Section 88 subsection 2 of LRA will be considered to determine the best interest of the child. So the fourth issue is whether the young age of all 5 children will support your claim. According to Susanna Ali, Section 88 subsection 3 of LRA provides a rebuttable presumption stating that CNG of any child below the age of 7 will be given to the mother with regards to the status quo of the child. 4 out of your 5 children are below the age of 7 and thus there is a rebuttable presumption that the CNG will be given to you. Justice Shankar in W&H held that strong grounds are required to rebut the presumption even adultery committed by the mother is insufficient. As for the 10-year-old, the federal court in Tae In Kim and Yu Peng Seong stated a 10-year-old child is in his tender years who is still dependent on his mother. As he is with you for the last 5 years and Frank left the home by abandoning his eldest son himself, it is highly likely the court will decide in your favor. In Ui Mei Ching and Michael Tan, the court held that the children grown together should be under one roof to find support and encouragement from the others with regards to their individual welfare as stated in Section 88 subsection 4 of LRA. Sivajodi and Kunathasan affirmed that the children should be placed in the CNG of the same person to provide mutual comfort to them. Thus, the CNG of all 5 children will be given to you to preserve their togetherness. Furthermore, the fifth issue is whether the wishes of the child and the parents will be taken into consideration as provided under Section 88 subsection 2 of LRA. As for the wishes of the children in Chung Ah-Meng and A. Francis, the court opines that the 10-year-old child is not old enough to realize what is the best for his welfare. As to the question of whether the child can express an independent opinion is subjective, but the court in Chung Ah-Meng and Francis Tay confirmed that the wishes of the child will be denied if it is not aligned with its welfare. Similarly, the wishes of the parents will be legally considered, but Viren and Deepak confirmed that the welfare of the child overrides parental wishes. Most importantly, the sixth issue is whether your claim to migrate to Australia with all 5 children will be detrimental to your application. Anis Suhaiza argues that the court has a restrictive view in removing children from their natural surroundings, and Section 89 subsection 2E of LRA allows the court to prohibit you from taking the child out of Malaysia. However, the federal court in Tae In Kim confirmed that the children are allowed to be taken out of Malaysia if their welfare will be improved by the migration. The apex court provided sole CNG to the mother and permitted her to bring the kids to Australia by stating that as the mother's future lies in Australia, it is the best interest of the children to be with her as they could benefit from the opportunities of the Australian system. As you will be completing your doctorate at an Australian university, you will improve their welfare with a better lifestyle and they will benefit from the Australian education system as accepted by the federal court, thus providing you sole CNG. As the CNG of the children will be likely to be with you, the next issue is what will Frank be entitled to. Frank will be granted right to access to the children as provided under section 89 subsections 2C and 2D. Despite the sole custody and migration to Australia, Frank will be allowed to visit the children with such frequency the court considers reasonable. But still, his lover will be prohibited from visiting the children as stated in Ling Sui Ching. In short, as the welfare of the children is the paramount consideration of an order for CNG, the overall interest of the children will demand you to have their sole CNG. Thank you.
Good evening, Mr. Nakiran. We've come today because we need your advice. So there is this child who my wife and I have been taking care since the day he was born. It's been 5 years now. And there is a problem because he is an illegitimate child.
The child belongs to Zali and someone named Mary. But the problem is now Mary is moving to Australia and she wishes to take the child along with her. Please advise us on how we can stop this.
Hi Zali and Zila. Most family matters regarding Muslim partners are handled by Islamic law, and for this advice, reference will be made to the Islamic Family Law Federal Territory Act 1984 (IFL). The first issue is what is the status of the child when it was born? Under common law, a child is considered an illegitimate child when it is born out of wedlock or an extramarital affair. Similarly, Section 110 of the IFL and the 64th meeting of Fatwa Committee in 2004 elucidated that a child who is born out of adultery is considered an illegitimate child. So, as your foster child is born to Zali and Mary as a result of adultery, the child is an illegitimate child when it was born. Thus, the next issue is who generally has the custody of an illegitimate child. Under common law, the federal court in Sin O. Casey Patterson and Chan Hung Po held that the custody and control of an illegitimate child lie with its natural mother until he is legitimated or adopted. Similarly, under Islamic law, the Sharia court in Mariam Nurisa and Huzairin held that Section 85 of the IFL exclusively provides custody of an illegitimate child to the mother. Thus, unless the foster child is proved to be legitimated or adopted, the legal custody of the child is with Mary. So, the third issue is whether the child can be legitimized. Under the civil law, a child can be legitimized under three ways, namely by the Legitimacy Act 1961, the LRA, and the Adoption Act 1952. However, Section 3 of the Legitimacy Act and the LRA, as well as Section 31 of Adoption Act 1952, expressly prohibits the application of those statutes to any person professing the religion of Islam. So, it is vital to consider whether Zali can legitimize the child under Islamic law. Although Section 114 of IFL allows a man to establish paternity through acknowledgement, the Sharia court in Muhammad Fawzul and Suhaila, referring to the 64th meeting of the Fatwa Committee, held that an illegitimate child born out of adultery cannot be legitimated even with the acknowledgement of the biological father. So, the foster child will never be attributed to Zali in any event. In such a case, both of you are required to prove that you have adopted the foster child to obtain legal custody of the child. Adoption of a child could be done either by an adoption order under Adoption Act 1952 or by proving de facto adoption, which could be registered under the Registration of Adoptions Act 1952, RAA. As Section 31 of the Adoption Act prohibits a Muslim to obtain an adoption order, the fourth issue is whether the RAA applies to both of you. Noor Izan Rahman, in explaining Tan Kong Meng and Zainon, asserts that the RAA applies to both Muslims and non-Muslims to register a de facto adoption. Thus, you will be able to register the de facto adoption of the foster child under RAA if you have satisfied the requirements of it. So, the fifth issue is whether both of you have the capacity to adopt the child under de facto adoption and register it under RAA. Section 10, subsections 2 and 3 of RAA provides that one of the adoptive parents should be at least 25 years old and 18 years older than the child, as well as an ordinary resident in Peninsular Malaysia. However, Section 10, subsection 2b also provides that if the child is illegitimate, a person who will be related to him, if he was legitimate, can apply for the registration too. Thus, if the foster child was legitimate, Zali would be its father, and as nothing is given on contrary, it is presumed that both of you have the capacity to register the de facto adoption under RAA. As both of you have the capacity to register the de facto adoption, the sixth issue is whether the requirement of a de facto adoption is satisfied under Section 6 of RAA. According to Tan Kong Meng and Section 6, subsection 1 of RAA, a child is stated to be adopted under a de facto adoption only if the prospective parents had continuous custody as well as maintained and educated the child for 2 years before the application for adoption under RAA. She explained that physical custody is insufficient to establish de facto adoption, but the child should be maintained, educated, and brought up under the complete care and control of the prospective parents, with no maintenance paid by the natural parents. As both of you had continuous custody of the foster child for the last 5 years, as well as maintained, educated, and brought him as your own with no aid from marriage, satisfies the requirements for a de facto adoption under Section 6 of RAA. Additionally, the child should be under 18 years old, never been married, and an ordinary resident in West Malaysia as required by Section 10, subsection 3 of RAA to be registered under the Act. As the child is only 5 years old and there is nothing contrary provided, the requirements to adopt the foster child under de facto adoption is satisfied. Although the requirements for the de facto adoption are satisfied, Section 6, subsection 1b of RAA requires the express consent of the parent of the child, which is married, to register the adoption under RAA. Zale's consent is invalid as he is not the legal father of the child. Thus, the consent of Mary is generally required. However, the proviso of Section 6, subsection 1b of RAA provides that the registrar can dispense the express consent requirement if it is just and equitable. In deciding what is just, she asserts that the registrar should take into account all events and conduct of the parties and provide importance to the welfare of the child. As Mary has abandoned the child to both of you since the day he was born and had no communication for the last 5 years, is a strong ground to dispense her consent, as explained in RISI. Furthermore, the next main issue is whether registration of the de facto adoption under RAA will provide complete legal custody of the foster child to both of you. As the RAA is silent on the legal effect of the registration, Haji Muhammad Naim argues that the Act does not affect the legal and biological status of the child. Similarly, Section 78 of IFL only provides the foster parents the duty to maintain the child and requires the child to be returned to the natural parents for a sum of compensation in their arrival. However, the federal court in Sin OKC affirmed that a Muslim couple can obtain complete legal custody of a child by a de facto adoption under RAA because the purpose of the Act itself was to safeguard right to custody of the adopted parents. In explaining, Tan Kong Meng, Nini Kamariam Majid stated that RAA recognizes the right to custody of the adopted child too. So, as both of you have satisfied the requirements for registering the de facto adoption, your right to custody is safeguarded and Mary will not be able to take the child away. Besides, common law will also prevent Mary from claiming legal custody of the child if the maintenance of the status quo is important to protect his welfare. In Masam and Salina Saropa, the foster parents were given custody of the child instead of the natural mother, as he has been living with the foster parents for approximately 2 years. As Section 86 of IFL also affirms welfare of the child as a paramount consideration in deciding custody of a child, the fact that the foster child has been with you since the day he was born will prevent Mary from claiming legal custody. Also, as you have been established the right to custody under RAA, Professor Matya argues that Section 48 of Child Act 2001 will prevent Mary from taking the child away to Australia because to relocate a child from one place to another, consent of the legal custodian is required. Thus, Mary will not be able to take the child away from you without your consent. In conclusion, your right to custody of the foster child can be established by registering the de facto adoption under RAA. Alternatively, the court can also provide you with the legal custody under common law to protect the welfare of the child. Thank you.
Hi, Mr. James. I'm Joseph Hill. I recently broke off my engagement with my ex-fiancée Olivia as she omitted from informing me that she's infertile, knowing it was important for me to have kids out of this marriage. She's trying to claim the money she spent on the marriage, and I want the engagement ring I gave her back. I have sent you all the relevant details. Please do advise me whether I can claim for the return of the ring, and am I liable to pay any damages to her? Thank you, Mr. James.
Hello, Joseph. You're in a bit of a pickle, but not to worry. I will explain everything to you. There are 5 issues with your case that I will address. Firstly, whether Olivia has the right to sue you under Malaysian law for a breach of promise to marry. Secondly, whether there was a contract to marry between Olivia and yourself. And thirdly, whether you have breached a promise to marry. Fourthly, whether you have any defenses against Olivia's claim and whether you may recover for the engagement ring. And fifthly, assuming your defenses fail, what damages you may be liable to pay. Let's deal with the first issue, whether Olivia has the right to sue you under Malaysian law for a breach of promise to marry. The case on point will be Doris Rodriguez and Balakrishnan in 1982. In this case, the court held that actions for breach of promise to marry are actionable in Malaysia. The statutory basis for Olivia's suit will be the Contracts Act of 1950 because the promise to marry is essentially a contract of marriage. And secondly, let's talk about whether there is a contract to marry between yourself and Olivia. A contract to marry has the same prerequisite elements for the formation of a contract. There must be an offer, an acceptance, and consideration. In addition, the parties must have capacity to marry. This means they must not already be married and they also must not be minors. Based on the facts of your case, these requirements seem to be already fulfilled. In short, there is a contract to marry between Olivia and yourself. On to the third issue. The problem you are facing is whether breaking off the engagement is equivalent to a breach of a promise to marry in law. In Frost and Knight, the court held that where a promisor announces his intention not to perform the contract of marriage, the promisee is entitled to treat the repudiation as a wrongful termination of the contract, and thus the promisee may bring an action for the breach. In your case, you have announced your intention to not perform the contract by breaking off the marriage, and therefore you have repudiated the contract in law, and as such, Olivia is entitled to claim against you. As the breach has already been established, the next issue is whether you have any valid defenses against the promise to marry. The issue depends on whether you have a recognized legal justification to breach the promise to marry. Therefore, the critical question to be answered is, what is a legal justification to breach the promise to marry? Under common law, there are 3 legal justifications. A, where the plaintiff had actively misrepresented some fact to the defendant. B, where the plaintiff had not disclosed some fact which goes to the root of the marriage. And C, where the plaintiff suffers a moral, physical, or mental disability that disables them from being fit for marriage. The first defense involving active misrepresentation would not apply to your case because mere silence does not amount to misrepresentation. Given that Olivia was merely silent about her infertility and she did not actively misrepresent her condition, as such, this defense is not available to you. However, you have the possible defense based on the fact that Olivia failed to disclose to you her infertility. You must understand that while a contract to marry is not a contract ob rema fide, that is to say, a contract which requires both parties to disclose all information, a contract to marry nonetheless imposes certain obligations to disclose information that goes to the root of marriage. The plaintiff's failure to disclose such information to the root of the marriage is a legal justification to breach a contract to marry. The case of Beachy and Brown explains what information would touch the root of the marriage. For example, debts owed or the temper of the other party would not be information that touches the root of the marriage. On the other hand, unchastity and immorality would be. In other words, only information that is significantly relevant would touch the root of the marriage. And given that you have expressly mentioned to Olivia that you would like to have children, her infertility is information touching to the root of the marriage. Therefore, a refusal to disclose this inability to have children is of significant relevance. Therefore, it is likely that the court will find that you have a defense. Secondly, you may also have the defense based on Olivia's permanent physical infirmity, which causes her to be unfit for marriage. The crucial question to be answered is whether Olivia's infertility is tantamount to being unfit for marriage. On this point, you may argue that your wish to have children is a fundamental part of the contract to marry. Thus, her inability to fulfill her obligations as part of the contract makes her unfit for marriage. In Jefferson and Pascal, the court provided that this defense is only applicable if the permanent infirmity was discovered after the engagement contract had been made. And based on your situation, the fact that you had discovered her permanent disability only after you were engaged to her will make this defense available. As you do have some valid defenses for the breach of promise to marry, now let's look at the issue of whether you can recover the engagement ring. Karamala Pillai suggests that there is a presumption that rings are an absolute gift. This opinion is supported by Cohen and Seller, where the court had held that a man who refuses to carry on his promise to marry cannot demand for the return of the engagement ring. However, there is an exception to this general rule. The exception is that where a man may recover the engagement ring when he has a recognized legal justification to breach the promise to marry. As I've told you earlier, you have two possible defenses. These defenses are also legal justifications to breach promise. Therefore, if these defenses are successful, then you will be able to recover the ring. However, in the event that your defenses fail, you must be prepared to pay damages. A party in breach of a promise to marry may be subjected to three types of damages: A, special damages, B, general damages, and C, exemplary damages. Special damages are awarded to compensate for any material pecuniary injury that has been proven to have been suffered as a result of a natural and not too remote consequence of the breach. In Olivia's case, these damages would be for her wedding dress, the deposit for the wedding dinner, and any other expenses incurred for during the wedding. Secondly, general damages are awarded as a reparation to the plaintiff for non-pecuniary injuries. For example, in R.S. Talachinimi and Sundaraju, the court granted general damages for the wounded feelings and pride of the plaintiff, ostracization from her community, and change in her position in life that the plaintiff had undergone in reliance of the marriage. In your case, Olivia is also likely to be able to claim for this ground. And lastly, exemplary damages are awarded as a form of punishment against the defendant. Exemplary damages are only granted when the defendant's conduct is sufficiently outrageous. For example, when the defendant has committed some sort of fraud, or was malicious, or was cruel. Fortunately, in your case, there is no evidence of misconduct on your part, and therefore, it is unlikely that you will be ordered to pay for exemplary damages even if your defenses fail. Good luck, Joseph.